June 25th marks the 7-year anniversary of an incredibly important and often overlooked Supreme Court decision, Shelby County v. Holder, which ruled crucial voter protections from the 1965 Voting Rights Act unconstitutional and outdated. This decision puts many communities, especially elderly, low-income, minorities, and student groups, at risk of voter suppression and discrimination. To understand the impacts of this case, we first need to understand the impacts of the 1965 Voting Rights Act. Widely considered to be the most effective piece of civil rights legislation in U.S. history, the act aimed to protect Black citizens' voting rights and outlaw discriminatory practices. A crucial part of these protections were largely dependent on two key sections, Section 4B and Section 5. Section 5 of the VRA required jurisdictions with a history of voter discrimination and suppression to seek preclearance from the federal government before changing their voting laws. The formula for identifying these districts was established in Section 4B. States such as Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, and Virginia were all obligated to submit election plans to prevent voter suppression, especially on the basis of race. Now, what changed after the Supreme Court decision? Why do people often say it gutted the VRA? Well, in 2010, when Shelby County, Alabama challenged its preclearance requirements, the Supreme Court was left to debate the constitutionality of Section 4B and 5. In a 5-4 decision, the court concluded that the formula in Section 4B was decades old, targeted practices that had been eradicated as the country had changed, and the racial disparity in voter registration and turnout was no longer the case in 2013. Without the formula, Section 5 was unenforceable. This means that regions with a history of racial discrimination no longer have federal oversight for their voting processes. Dissenting justices said that the only reason these practices didn't exist was because the preclearance requirement was doing its job. Justice Ruth Bader Ginsburg likened the decision to, quote, throwing away your umbrella in a rainstorm because you are not getting wet. Because the court only struck down the formula for determining which jurisdiction should be subject to preclearance and did not strike down preclearance itself, Congress can pass a new coverage formula at any time. But, as we know, it has been 7 years since the Shelby County v. Holder decision, and Congress still hasn't created a new formula. However, simply reinstating Section 4 of the VRA would not be enough. Even before 2013 and the Shelby County decision, states without preclearance requirements were enacting stricter laws and discriminatory practices. The criteria for preclearance must be expanded and strengthened in order to protect American citizens. If you can, get out and vote. To register online and for more info, visit rockthevote.com.